And good morning to all. Thank you very much for being here today with my colleagues Ed Januccio and Michelle Lee of the GLMR law firm as we talk a little bit about design law updates. We have an interesting presentation with some perspectives on Australian law and then a follow-up with US perspectives and some Q&A. I'm going to turn it over to Ed and for the presentation. Thank you very much. Ed, take it away.
Thank you, Babak, and hello, everyone. We appreciate you coming in and listening to us today. There are some real peculiarities between Australia and United States law in particular, and I thought I'd start with a really big one, and that's the copyright design overlap. And not many people have heard about this. We were talking before with Babak, and his son is just finishing his law courses, and he's finished copyright, and he did not touch on this. So it's quite an interesting piece of law for you all to be aware of. In Australia, like a lot of places, copyright is an automatic form of protection which exists in artistic works. And the copyright owner is entitled to stop others from unauthorised reproduction. But in Australia, it's so long as it stays an artistic work. And the interesting feature is that the artistic quality is relevant, not in relation to the work itself, but in the craftsmanship employed to create the work. So it comes down to the judge's decision as to what is an artistic work and what is artistic craftsmanship. But in Australia, so that you don't get two types of IP protection, copyright is no longer infringed once the design has been industrially applied. So what does that mean? And I've shown you some examples here in the slide. Notionally, industrially applied, the courts have determined is 50 or more products. So increasingly, particularly in fashion, for example, the fashion designers like to put all their products on social media sites, Facebook, Instagram, so on. And it's quite easy to copy when you're already shown the designs. Then what happens with 3D printers? These 3D printers very easily can make solid products of artistic works. So it's quite easy to hit that 50 mark for products sold. As soon as that industrial application has been hit, you lose your copyright. So conceivably, a designer is left without a remedy, particularly in circumstances where they do not have a substantial reputation to rely on under other parts of Australian law to do with misleading and deceptive conduct and so forth. So in this part of the law in Australia, it's much better to be proactive rather than reactive. So what do you need to do? Well, you should, if you are going to industrially apply an artistic work, file a design registration. So in Australia, just like the United States, the design registration covers the overall visual features of the product. In Australia, it's a shape, configuration, pattern and ornamentation crossover that doesn't appear in the United States, but you should certainly be aware of if you're selling products into Australia. Don't rely on your copyright. Think about design registration. We'll allow questions later on, and certainly if you have any questions, please put them in the chat and we can answer them. I'll now pass to my colleague for the next slide.
G'day everyone. So our next topic of interest are graphical user interface design rights in Australia, which we've affectionately termed GUIs. And this will be quite a topical area of interest for many tech companies. And so graphical user interfaces, that could include screen icons, effectively an application that you see on your phone or your tablet. And as many of you will be aware, lots of jurisdictions around the world, such as the United States and the European Union, they currently already provide registered design protection for GUIs, but Australia has not quite yet adopted the same approach. And there's a little bit of a question currently regarding the enforceability of GUI designs, which I'll go into in a little bit more detail. Now, the Current Designs Act only allows protection for the overall look of a product with a physical and tangible form. And a product is defined as a thing that is manufactured or handmade. So if you think about it, GUIs aren't considered to be products of manufacture because they're not usually visible on a display screen of a device when it's in its unpowered or at rest state. So the visual appearance of the graphical user interface is not usually considered to contribute to the overall appearance of the product. Now, to clarify, the current Australian Design Office practice requires that the use of the visual features of a product must be assessed in the context of the product at rest, as opposed to in use, so the powered state. So for products that are powered by electricity, the appearance of the product in its powered state should not be considered. But it is also important to know that this is the current Design Office practice based on a decision in 2017, and it has not yet been tested in court. And as you can see there, Australia has a two-step design process. So we have a formalities design examination process prior to registration, and then you can do substantive examination and certification post-registration. So an enforcement can only occur after step 2, and also the validity of the design is only determined after step 2. So no one really knows what's going on yet at the moment because there hasn't been a court decision for it. But the good news is only very recently, about 2 weeks ago, IP Australia proposed to introduce some amendments to protect virtual designs. So that includes GUIs, your animated icons, it also includes virtual reality displays, amongst other things. So there you go. We've got a bit of an update in Australia at the moment, which could be great news for everyone. Now we'll move on to the next slide, which I'll very quickly go through as I'm mindful of time. We do also have a replacement parts defense to infringement in Australia. Now, to satisfy this provision, the part that you make needs to be for the purpose of repair to restore its overall appearance in whole or in part. Now, this provision doesn't provide a defense against infringement for use of a component part where the purpose is to enhance the appearance of the complex product, so the product that it is assembled to. So the government effectively introduced these provisions to encourage greater competition in the spare parts market. And you can see some examples there of car bumpers, for example, or vehicle grills. And the case in question, which is the GM Global Technology versus SSS Auto Parts, which was from a few years ago, related specifically to the aftermarket or spare parts for car manufacturers. So in the case in question, the court decided in favor of a supplier of the aftermarket spare parts for cars. And the third point there, you can see a key aspect that the decision turned on is that the registered design owner, the onus is placed on them to show that the infringer was actually making the parts for other purposes than for repair. And so, it's still worthwhile to seek protection for spare parts that can be used to improve or enhance the appearance of a complex product, because this can dissuade third parties from copying or selling that spare part design. But I think the key difficulty here is in proving that the maker of the spare parts was actually using it for other purposes other than for repair. So I'll now pass you back over to my colleague, Ed, to talk about shape design and shape trademarks. Thank you, Ed.
Thank you. This is a really interesting one that I thought I'd throw in for everyone. It's just something that a lot of practitioners would not have thought of. And it's not necessarily about the law, but it's just an interesting strategy that I used. This is a tent here that was filed. The patent was filed in 1984. This patent was actually the most litigated patent, Australian patent ever. It's been tested in Japan, the UK, Germany, Europe, UK, Australia, and it lasted the 20 years. So it was very well drafted, and it was a very, very successful tent and made the company, a lot of money. But it also increased their reputation. And this particular tent, as you can see, has a particular shape. And coming up on the 20-year term, the client asked me, well, what are we going to do now? We're about to lose our patent rights. We've been very successful in enforcing our patent rights around the world. What are we going to do? And then I thought up of this idea of switching into shape trademarks, which are protectable in Australia. So you can see below there, sorry, I'll go to the next slide. Sorry, next slide. You can see how we filed shape trademarks for the shape of the tent and the shadow of the tent shape. And we started to use these shapes in our marketing for the client around use of buying and selling tents. And this has allowed us then to at least take some action against competitors trying to copy this tent. Now, the patent obviously has expired, but under Australia, we have common laws of passing off and misleading and deceptive conduct. And where people, particularly in their marketing literature, quite often will insinuate that they are related to this original tent, we can certainly attack them and at least come to some sort of agreement for our client, who has established a very large reputation over 20 years for tents of this particular shape. So I thought that was just an interesting slide to put in to show you how you can go from a patent to a shape trademark and extend the life of your client's products by being a little bit tricky with your IP strategies. I think, Michelle, over to you on grace periods.
Thank you, Ed. So very simply, we're finally in line with the rest of the world for grace periods with designs. So again, a grace period is, it protects you from inadvertent self-disclosure, which is, publication or use of your design prior to filing. And so this bill was passed only just under 2 years ago. So it's a 12-month grace period, and it applies to disclosures after 10th of March, 2022. And this is now in line with the grace period provisions available in the US and Europe, for example. The couple of key changes were also made around this time, and that because of the grace period. So there's now a prior use defense. Because the grace period can now be strategically used by designers to allow them to test the market before they register a design, there is, this could leave competitors exposed who don't realize that a design has been registered, and then they go ahead and make the product. So to deal with this issue, a prior use defense to infringement has been introduced, and it provides an exemption to infringement for acts that commenced before the priority date of the design, where, basically it doesn't catch out someone who's unaware that an owner has decided to register that design. And relatedly, there's also a innocent infringement provision. So it introduces protection for those who infringe a design between filing and registration, but had no way to know that the design was protected. So the two go hand in hand, and they all basically have come about because of the new grace period provisions. So it's a very quick and easy topic. And I'll pass back over to Ed to talk about multiple designs.
Thank you. So look, Australia has not had multiple designs. I know in the United States you don't. So we've changed our laws, though, so now that we're in line with Europe. So now we allow multiple design filings in Australia, as long as they're in the same Locarno class. There's really little benefit in filing these in Australia. unless you're doing a large number of designs filed simultaneously. The fee, there's a small discount, but really not that much. They are all connected and there's central examination and so forth, and you don't need to drop embodiments. So there may be some benefit to having them, but we thought it was important that you can now consider. You might think, for example, related products such as earrings, necklaces, sculptures, for example, that are in separate subclasses but in the same Locarno class, you could be a little bit tricky and file a multiple design because the law only says the same Locarno class, not subclass. So you could be a little bit tricky with how you want to file and gain that small benefit off the filing fee. There's a couple of other interesting new notes that I'll just quickly share with you that aren't on the slides. The first is that Australia is looking to introduce partial design law. I know that in a lot of the places in the world you're allowed partial designs. So in other words, protection of the handle of a cup rather than the cup and handle together. You have been able in Australia to be a little bit tricky again with our statement of newness and distinctiveness and the use of broken lines. But technically partial designs have not really been allowed in Australia. It's just the attorneys have been clever in how they've been able to file the applications. So IP Australia now have made it clear that they would like to actually formally allow partial design. So that will certainly bring us in step with the rest of the world. And one really exciting new feature that I was talking to Babak about earlier is that IP Australia is considering the introduction of what they call incremental designs. And this is going to allow designers to protect their designs as they develop their products throughout the life cycle. So what does this mean? It's a little bit like a provisional application. So the designer can go and file a low-cost application for a preliminary design and then can further develop the design for up to 6 months before filing a main application for a design with incremental changes. So it's a bit like a provisional and a complete utility application, if that makes sense. It's only proposed at the moment, but it's going to be quite interesting how that plays out throughout the world. I'm not aware of any other country that has such a system of incremental design rights where you can link them and you get a smaller fee for that initial low-cost application in the beginning being your preliminary design. Quite an interesting proposal from IP Australia. I'll now pass to Babak to start the US slides.
Thank you very much, Ed and Michelle, for a very interesting presentation. I carefully listened to the copyright overlap, the GUI work that you're doing, the replacement parts defense area, the crossover with the trade dress work, grace period, and multiple filings. Those are all very, very interesting, and I will focus my presentation to address those so they can, audience can get an appreciation of the different perspectives of the same thing that we're looking at. I have some questions in here, and if you wish, people who are attending, you can just select one of the options, and then we will see the results on the next screen. It's kind of an interactive thing, and I appreciate you selecting. So let's give it a try. If you want to give it a try, I'm giving you a couple of seconds. How familiar are you with design patterns? I'll go ahead and select something myself. Give some time for people. Give you a couple of minutes here to decide. We have a few options. Kind of fun. I think we have about 9 or so, or 10. Okay, that's good. We have a few votes, and let's have a look, see what it looks like. We'll give a chance for other questions. So as it looks like, majority of people here are more familiar in this somewhat familiar category and have filed a few, which is not uncommon as to most practitioners. There's not a lot of people who do this all the time. A few of us who do a bit of it, but in general, as a part of our other practice. Another question here to see, gauge your familiarity. In the US, design patents protect how something functions, how the design may be used, source of goods in commerce, or the overall external appearance of the design. I'll go ahead and let you guys pick some questions. Again, I appreciate your interaction here. Thank you very much for your participation. It makes it a little bit more interesting for all of us, and we get a sense for our audience. Well, not our results yet. Let's skip forward somehow. Okay, so in the US, when we're looking at a design patent, it protects the overall appearance of an article of manufacture. That's the big thing right there. And it's an external appearance of the device. It's good for 15 years. There are no maintenance fees. And since we were talking to our Australian colleagues, the point of reference between us and them is this 6-month window to claim priority. So if I have a design case that's filed in the US and I wish to go off and get the priority filing date for that in Australia, I need to do that within a 6-month time frame. What are the kind of things that designs protect for us? Is the overall shape, surface ornamentation, a combination of things. And in terms of graphical user interfaces go, it pretty much covers an icon that's embedded on the screen that's available for us. Okay. The rules that are applied for design patents in the US, unlike Australia that has a registration system first and then followed by an examination, here in the US, you have to go through a full examination process, and the application is checked for all the same rules that are applied to a utility patent. It has to be definite, enough information to convey the design. It has to be new, and it has to be non-obvious. In addition to the same rules that apply to utility patents, a US design patent also has to be primarily ornamental and not primarily functional. So that's another threshold that must be met here. Same things, kind of things we get to expect here, because it is not a registration system and examination system. We have double patenting, rejections that could be seen. We get restriction, which is a very important area in case of the multiple designs. Yes, you are able to try to put multiple designs in one US design application. The rules are that the multiple design applications will be kept together and will be examined by US design examiner at the same time, so long as they are patentably indistinct, meaning that they are similar enough that they're almost the same things, right? So in that case, the examiner will go off and do the examination and apply it the same way. And then likewise, when you go off to enforce it, you have to deal with those kinds of things. So what ends up happening here, the unelected embodiments, if the things are not patentably distinct, if the shape is too different from one another, then you need to follow divisional applications in the United States, because the old rule applies, meaning that whatever is disclosed in a patent application that is not claimed, then it becomes dedicated to the public. So if you have two designs in your design application and you choose to prosecute one and you choose to give up on the second one, well, that second one is now freely available to the world to copy because you have disclosed and unclaimed. So that's something to keep in mind. Another thing that you have available to you for product designs is expedited examination, and you can go through this process very quickly, pay more money, and get your design granted quickly again. So what do we need to do? Again, the drawings are very important. Since in the US we have options for partial designs, the major takeaway is you should really be thinking about the infringing product that you wish to enforce your design against. And with that in mind, include as much detail as you would like to have. Details that you wish to enforce, you should include. Details that are too much for a knockoff to not copy, then you should leave off. And that becomes the practice that's available. In terms of drawings, sometimes we like to be, expedite things and use a photograph, and it just should not be used, because essentially the infringing product has to be substantially similar to the image of the photograph. And the patent office just doesn't like to see them because they can't reproduce them. Another question here as we shift gears and go over to the graphical user interface, I'd appreciate it if you could click on this one. So I get a sense for how familiar you are in the GUI protection. So how familiar are you with protection of graphical user interfaces? You file several a year, somewhat familiar. You know what they are, you've never seen it, or you're not even sure what a GUI is. So let's take an option here. Thank you for all the participants. Really appreciate the comments. Let's wait a little bit more. Let's see if we got ourselves some results now. Okay, well, that's good. That's good. That's good. At least one or more filings. No one's done a lot. And oh, we got a couple. So a GUI is a graphical user interface. That's the thing on the computer screen or your handheld or your tablet that allows you to interact with the piece of software. So that's the graphical user interface. And these days, for the most part, in terms of electronic commerce goes, a graphical user interface is really your electronic storefront. It's really the look and feel of that piece of commercial product. So a graphical user interface is ruled by the Patent Office procedures. The Manual of Patent Examination and Procedure, Section 1504, tells us that it has to comply with the Article of Manufacture requirement, meaning that a design is a part of an article of manufacture. It is not separate and distinct, but is applied to a widget. So that's what an article of manufacture is. So it is inseparable from the article to which it is applied. So for that reason, you need to always convey to the Patent Office what is the object that this is applied to, from which it is a part of. So in this case, independence of the design on something outside of itself is not a reason for holding it's not a design. So that itself is an interesting background. There was a famous In re Ruby case. There was a design patent for a water fountain. And there was some discussion as to the fact that, well, we can't necessarily get a design patent for the shape of a water fountain because it really comes from the nozzle. And no, the law was such that, no, you can do that. It is okay to have a shape of a water fountain as a design itself. And the same law was extended to allow the existence of an object on a screen, essentially, that is the information on a display of a screen. And by the same extension, we have this graphical user interface. And nowadays, it's about 6% of the designs, not a lot, and it's approaching about 20 or 20% the last time we checked it. So let's look at this In re Ruby case. This is the In re Ruby case. It's an old case, 1967 case. It's a design for a fountain, and that became the legal basis for us to today have a design patent for an icon that's on a computer screen. And of course, on the right-hand side, we're seeing the famous iPhone display that was the topic of the major iPhone wars for a few years that I think definitely hammered home a value of GUI design patents. So another question, GUI protection is available for icons or symbols or layout on the screen, a typeface, commonly referred to a font, or animations for logos, screen elements, all of the above, A and B and not C, A and B and D and not C, or C only. Let's give it a try, see what you think about this question. It's kind of a toughie, but it's kind of fun. Well, that's kind of a tricky question on my behalf. It's really for all of those things. You can get a GUI, a graphical user interface protection here in the US for every single one of those things. You can get graphical user interface protection for the overall appearance. You can get protection for individual unique icons, typeface, et cetera, et cetera, et cetera. Each one of these things is available for protection. Sometimes you may see graphical user interface that includes both of those things. So what's available, we can get it for pretty much the look of the software as we mentioned. And the look of the software is determined by the different icons, symbols, the layout, typeface, 3D objects, virtual reality animations. Just really go for it. Whatever you have that is creative, that is new, that differentiates you from your competition, it's available for protection. The title is almost like has a magical language. You have to say it is a display screen or portion thereof with a graphical user interface for, because at the end of the day, we're talking about this is an article of manufacture that has a design associated with it, which is inseparable from the article of manufacture itself. So that's why the title cannot be GUI 4, but it's really a screen that includes the GUI. So we have to show that the screen is not there, and that's why we draw these dashed lines around the perimeter to convey that information. There's usually a descriptive element that talks about it as we move to animated GUIs, and these are the kind of the splash screen or shifting screens as we go from one menu to another, things of that sort. So again, there is a certain way that the patent office likes to see that, has to be conveyed that you have a series of images and that the transition from one to the other is or is not part of the design. Takeaways for design patents: you can get a very large protection. It's available to you. It's rather broad, especially with respect to GUIs. Data-driven GUIs, even busy ones, are okay to get protection for those. Prosecution can be quick. Allowance rate for GUI design applications as well as regular design applications are about 90%. And that's not to say that the patent office people are not doing their job examining. No, they are indeed doing their examination. It's just that people will not go off and file new design applications when they don't have anything new to begin with. So it's really a product driven and it's innovation driven. And so for that reason, it's kind of almost natural to get these high enforcement allowance rates. Also, it's relatively easier to enforce than with some utility patents, especially here in the US with respect to the Alice rejections and the Section 101 that is hitting the software world. This question is here for all of us who wish to get a continuing legal education credit. So if you are here still, if you click yes, then you will get credit. And I think it's good to go. Let's move on. We can skip it. Here's what I'd like to talk about, some big changes in China. In China, until June 2021, doesn't seem like it's a long time ago. It's a while ago, but it's just the noise doesn't seem to resonate as importantly as it should. In China, you could not go off and have two things. You could not have a partial design, and for that reason, all of those graphical user interface cases that were filed in China had to be associated with a physical device. They could not separate themselves for it. And so this idea of a GUI protection did not exist. And the idea of a partial design that earlier Ed and Michelle were talking about did not exist. So first and foremost, the introduction of a partial design is a tremendously huge area for work in China, because of a lot of our clients would file there and they would run into this wall of non-availability of partial designs. And then the lack of availability of proper enforcement of GUI applications in China because of the requirement to include the hardware device is also gone now that we have the availability for partial designs and GUIs in China. So this is really, really important. And I would just like to just kind of emphasize that. So what we have now, effectively, the terms of the designs in China have been aligned with the rest of the world up to 15 years. Even the US did that. Protections for partial designs are available. It's very, very important. Use of dashed lines similar to Japan and US and Europe is not allowed, which is, again, very nice in terms of concordance of these design regimes. However, shading is still not available, so we have to be careful about that. The other point is that you can now have prior design filings in China. So effectively, you can have a continuation practice in China, which is again a very, very important, significant addition there, especially since a lot of people seem to take their U.S. applications and also enforce it there in China. So partial designs and graphical user interface in China, extremely, extremely, extremely important. So just keep that in mind. All right. So when we go off with all of these things in mind, what's available in Australia, what's available in China, what do we do? We try to keep in mind all the different possibilities. We try to keep in mind that the deadline to foreign file comes up real quickly within 6 months. That's a very, very quick time frame. And we try to engage with our outside counsel. We try to engage with Ed and Michelle to give them a heads up as to, hey, here's what we're thinking of filing in Australia. What do we do? And they tell me, hey, look, GUIs are not going to be examined. They're probably going to sit over there and be parked until the regime changes. So that's the kind of advice that's good to have before you file. And with that in mind, it's good to kind of send your applications with, prep them with that in mind. And that's why we're talking about, front load with multiple embodiments that accommodate those things that you may want to do, that you may perhaps not be able to do so here. GUIs as well as the designs, things like that. In terms of multiple designs, again, this kind of comes into play. When we have multiple designs in the US, again, the filing of a preliminary amendment is important because we don't want to have things that are disclosed and claimed. But again, if we wish to go off and use that application as a priority application for overseas filings, let's say in Japan, then we need to be careful to include all those embodiments that we wish to have for our priority claim first, prior to us doing that to our application in the US. So again, you need to be careful about those things. Yes, you can front load, but you need to be careful there.
Babak, just quickly, on that, and just for your clients, and you'd be aware of this, it's very important to get good drawings done right in the beginning in consideration of all those countries. So often we see people don't want to spend money on getting good drawings, and all that does is increase your costs in examination all around the world. So I emphasize, think about the other countries and get drawings suitable for those countries. You talk shading. Sometimes in Australia, we will actually file 2 sets of drawings in the one application, a set with shading ready for the United States Convention filing, and a set without shading for use in countries without shading. So I think, as Babak said, if you think about these things up front and you prepare yourself up front, you will end up saving a lot of costs later on during the prosecution and examination of these designs.
Yeah, so well said. It's just, I'm glad you said that about the drawings. It's just that for the years I've done this, I cannot overemphasize the need for good drawings. Clients always, well, I got a draftsperson, I know what I'm doing, let me send you some images. And always ends up costing more. And so doing something right the first time is so much nicer, because now you have a complete set of drawings that you can use all around the world in whatever flavor that you want, and everyone's always happy. And that usually is what upsets the client is, oh, we need to fix the drawings for Australia. Well, didn't we already file in the US? Yeah, but those drawings were not good, but now we need to, and then the same. So you cannot emphasize. And then just today, as a part of my practice as a patent attorney, I received an office action for a case for a client who happens to be an Australian client, and it's a design case. And the examiner is saying, I could read it to you. It says, quality of drawings in a design application cannot be overemphasized. I cannot reproduce this. So I just copied it, went back to the client. I said, look, you see, here we are, and we really need to make the drawings now. And this time, no, it's not me saying it, it's not Ed saying it, it's not Michelle saying it, it's this ink and on this office action from the patent office. And now the client's like, okay, fine, let's please use the professional illustrator to make the design drawing. So it cannot be overemphasized, and I'm not going to say it anymore. All right, I think we got some questions here. We're going to switch gears because Ed and Michelle talked about how with their 10th case, when the patent came off of term, they relied on a trade dress protection to extend the life of their design. So here we are looking at trade dress and design in the US. So let's see what the answers are. Can I get protection both at the same time? And yes, absolutely you can. The nice thing of it is the difference is a trade dress in the US is part of a trademark, and its goal is to identify the source of goods. That's it. That's its job, right? Indicates who makes or sells the product. Whereas a design patent protects new, we said section 102, original, as in not a reproduction, and ornamental design, as in non-functional, not intended to identify the source of goods, right? So if you have a brand new product, unlike Ed and Michelle's wonderful tent, that's brand spanking new, no one recognizes the shape. So you're not likely going to be able to get trade dress protection for a shape because it hasn't acquired distinctiveness yet. But you can go ahead and get yourself design patent protection, right? And then as time goes on and you get to the point that your patent is now expiring, and hopefully you have developed enough of a market awareness, then you can go off and get trade dress protection, even though the design is no longer new. So that's the interplay that you have here, as well as the same thing. For the same reason, for new products, product configuration, packaging, and just cool gadgets that we see every day, medical devices or kitchen appliances or cookware or you name it, then it's very possible for there to be at the same time for a given product, design patents, trade dress, copyright protection. So all of these regimes are available for protection for a particular product. And unlike Australia, we don't have this rule that says, my God, if my copyright in my labeling for my packaging is used more than 50 times, I'm out. So that's another nice thing. But we have it. The regimes are available. Again, keep in mind that for design patent, it has to be new and non-obvious, whereas no such requirement is required for your trade dress. When we compare to copyrights, again, here, the advantage is again, we don't have the requirement of this non-functionality, and we don't have the requirement of separability. If you recall, we started the slides with the picture out of the MPEP for a piece of furniture for a design patent. The example I've heard from my copyright partners is that if a design is really, really ugly for a piece of furniture, you may get copyright protection for it, because it is separable from everything functional about the design. Whereas here, for a design patent, we're talking about the industrial design or ornamental design for an article of manufacture, for a widget. So here, we don't have the separability issue. And then when it's time for enforcement, as we were talking earlier with Michelle and Ed just before this call, you don't have the subjective factors that you have in a copyright case. It's a patent matter. It's a substantial similarity, and it's a visual similarity test. So it's a lot more advantageous to us in terms of copyright. No, it's not an exam, not a registration. It's an examination, but because of that, you have this additional assurance. Interesting updates that I would like to just talk about in terms of the recent case law. We'll talk about just the fun of it. The fact that we are here with Michelle and Ed is that design patents are really relatively inexpensive, and they allow for quick prosecution and really enhance your utility patents portfolio and really do a nice job of enhancing your branding portfolio and give you additional teeth. We know that they have advantages over trademarks because you don't have to have acquired distinctiveness, and at the same time we don't have these requirements of access and that you require in infringement in copyright. And then this myth that, oh, they're not so good. Well, I think we saw in the big cases with the Apple v. Samsung cases that these things have teeth, and then by filing multiple designs, as we talked earlier, in even Australia, here and elsewhere, you can get adequate level of protection for your design without any concern. There is recent case law in the US that's interesting. I'm talking about this one because it ties in nicely to the replacement part defense that's going on in Australia. Here in the US, there is this old doctrine in patent law, what is permissible repair and whatnot. But here we're talking about two design cases. This was also a GM case, as LKQ versus GM. A couple of design patents. One of them was for a skid bar. That's the thing you have in the front of your, car as you go and hitting bumps and stuff. And the other one is a quarter panel you're seeing there in the right-hand side, quarter front, quarter panel of a car. So what happened is LKQ went off to the PTAB and tried to invalidate these two patents and to say that, hey, they are either anticipated or obvious. And what ended up happening is that what's really nice about this case for now, people were not sure what is the test for obviousness when we are trying to look at a design patent. Is the KSR test applicable here? And at least we know in this case, when the Federal Circuit dealt with it, they said, no, KSR is for utility patents. And here we are talking about the design patents, and the well-established Rosen and Derlin test remains. And basically, when you have a design patent and someone wishes to find obviousness, there's a two-part test where in part one, you need to find a reference, a primary reference that's basically the same, right? Basically the same primary reference. If and only if you have demonstrated basically the same primary reference, now you may go to the secondary reference and fill in the gaps that are missing, so long as that suggestion to make that substitution exists in that reference, right? So it's a very tough test to do that. And the reason for it is it was established in that sense because everybody knows, as we said earlier, a design patent is there to protect the overall appearance of the design. And if the test was such that it allowed someone to pick and choose pieces of things, then it would be not too difficult to grab a primary reference that has a line in it and another primary reference that has a curve in it, and you begin to basically construct the world out of these pieces. And so for that reason, in this case, this old test remains, and that's a very nice development in terms of design patent world goes. Now, the jurisprudence of this case is such that the LKQ people pushed back, and they said, yeah, we understand that that maybe this test is not so bad. But what we're saying is, when KSR came into play, the idea was that the old test for having to find teaching, suggestion, motivation, or whatever test that we had before for finding obviousness was too rigid and too rigorous. And so LKQ argues that, we need the test that is also not too rigid and too rigorous, meaning let us have a primary reference that's not basically the same. And so we can march on. And in this case, that question of, whether the, In re Rosen and Derlin should be thrown out was not before the court, and they kind of danced around it, even though there was some opinion that says it stays. But for now, we know that for design patent holders, obviousness is going to be harder to prove, especially because this test remains. So that's a nice thing for all of us design patent practitioners. So I'm going to stop here and let us have some time for some questions for Michelle, for Ed, or myself on Australian law or U.S. law or anything of the sort. And
Babak, there's one question there from William at the moment. That is not permitted in Australia, but you could talk about the United States.
Okay, there we go. I've heard that one can file a continuation of a U.S. utility patent as a design patent using one or more fluid. Okay, so the question is, I believe I've heard that one can file a continuation of a U.S. utility patent application as a design application using one or more of the figures in the original utility application. Is that true? Yes, that's true. It's correct. I have done that myself several times over the years. What's required is that the drawings have to be of sufficient quality to convey the design. And so usually what we try to tell people here is, if when we're working on something that is of a mechanical nature or something that has a design aspect to it, we might as well get a few more drawings that I would say are perhaps unnecessary for a utility application, because we may not need to know the top and the bottom and the left and the top and the back and the sectional view of a gadget, but we may include it in a provisional filing. We may include it in a utility patent application for which to be able to file a continuation. So yes, you can. The rules apply, all the rules that apply to utility patent application, including continuation, apply to designs. You can even file there's a case I think we talked about earlier that you can go the other way around as well. If your design application has sufficient drawings and details, you could go off and file a continuation the other way around. Usually not done, but there is actually a rare case on that as well.
So, Babak, one thing I'll say for Australia, so we can't do what William has asked, but in Australia, typically because of the Apple Samsung cases and now that clients have understood the power of design patents around the world and why you should have them, we quite often, when drafting a provisional application, we'll look to file a design application at the same time. So we'll be filing a utility and design patent on the same day at the same time with some of the drawings. So it's not a continuation, as William has mentioned, but certainly in Australia, when we file a provisional application, we quite often will try to file a design application. I do a lot of litigation mediation, and I find that when I'm in mediation, if I have a design patent, I only need to talk about the visual appearance, and I don't need to argue with the attorney on the other side about claim language. It makes it a lot easier if you have a picture, and being a simple person that I am, pictures are much easier in a mediation to get to some sort of commercial agreement than arguments over claim language. Absolutely
right. I mean, we have the same. It's interesting that your practice here and ours here, to the extent that the system allows, is the same. Comes up all the time. Hey, I need to file a utility patent application. I also have a design. I can file, and the point is, no, you cannot get priority to your provisional in your design, and those two must be filed at the same time in the U.S. as they're in Australia. So that's another one of those tricks. All the rules are the same except when they're not. So, yeah. Thank you very much. Any other questions from the audience? We'd be happy to take. And of course, here's the contact information for Ed, Michelle, and myself. And we'd be happy to.
And I believe also our thank you to our producer, Alex. He has put a PDF of the slides on the platform that you should be able to obtain.
That's right. Very good.
Thank you very much, everybody. We appreciate your time today.
Thank you all. Thank you, Ed. Thank you, Michelle. And thank you for participating all.
Fantastic. Have a lovely day ahead.
Okay. Bye-bye.
See you.